In this episode, we take a look at the murder of a tribal woman that has refueled decades-old tensions in Odisha. We also talk about how India has been drawn into the investigation of Australia's deadliest mass shooting in recent memory. But we begin today with Karnataka's new hate speech law. Hi, I'm Ichha Sharma, and you're listening to Three Things, the Indian Express news show. Last week, the Karnataka government tabled a legislation in the State Assembly aimed at tackling hate speech. Titled the Karnataka Hate Speech and Hate Crimes Prevention Bill of 2025, the bill says its objective is to curb and prevent dissemination, publication, or promotion of hate speech, while also providing adequate compensation to the injured victims. The bill also proposes stringent punishments, including imprisonment of up to 10 years, and grants the government the power to block or take down online content that is deemed to be hate speech. It is these sweeping powers, along with a much broader definition of hate speech, that have raised concerns among critics who fear the law could be misused by the government. To understand what the bill entails, my colleague Shashank Bhargava speaks to the Indian Express's legal affairs editor, Apurva Viswanath.
Apurva, I suppose it's fair to say that hate speech has unfortunately become part of much of our online and political discourse, and we've seen more and more of it over the past few years. So can you tell us how the law currently tackles this issue?
So, we don't have one specific law that deals with hate speech because it's also a difficult thing to categorize and box in a sense, right? So what we have is a cluster of provisions in the Indian Penal Code, now the Bharatiya Nyaya Sanhita, which deal with specific aspects, and these are the provisions that are invoked essentially to tackle hate speech. So these sections provision speech that outrage religious feelings, or say damage a place of worship, or trespass in a public burial ground, and also what are deliberately intended to hurt the religious sentiments of an individual. So broadly, hate speech is around religion the way we define it.
And talk about how this new bill defines hate speech, because in any law, the way you define things ends up determining how it will be used, right? So how is this bill defining hate speech?
So what's interesting about this Karnataka bill on hate speech is that they are looking at a more expansive definition of hate speech, right? So they're looking at not just religion, but caste, sex, place of birth. Essentially, these are the same factors which are constitutionally protected as fundamental rights, that there cannot be discrimination based on caste, religion, gender, sex, place of birth, right? So Karnataka's hate speech laws look to incorporate all of this. Say suppose someone is dog whistling against a particular caste or talking about Dalits in a certain way, that also would come under hate speech. Normally, this would be an offense punishable under the ST's Atrocities Prevention Act. But now, additionally, if the Karnataka police decides to take action, it would also be under this law. But having said that, the definition is not really the problem. Or having a law with an expansive definition doesn't solve much, because the issue with punishing or policing hate speech is how political forces, how the state really implements the law.
And in that regard, and this is something that we've spoken about in the past as well, if the definition of something, in this case, hate speech, is broad enough, then a government could categorize any number of things as hateful. For instance, content that doesn't align with its political agenda or that criticizes it could then be counted as hate speech.
Yeah, absolutely. Because especially with laws that impinge on free speech, the broader they are, the more expansive they are, the more amenable they are to being used arbitrarily against a citizen, right? So, and this is also a problem because the person implementing these laws at the most basic level or at the first step is a police constable. So that police constable can't really decipher these overbroad definitions and see whether your speech fits in there or not, right? These are people also who take cues from their political masters. So depending on which government is in power, how they want to look at a particular speech, that's how it's going to be policed. Very good case in point is how the Assam police is looking at hate speech laws, right? In the last say here, the Assam police doing a serious crackdown on instances where apparently online speech after the Pahalgam incident or after Operation Sindoor, and they've made several arrests, and that is a political call that sort of has been taken, that no matter where in the country we find, say, a WhatsApp message or a Facebook message which is allegedly inflammatory talking about these incidents, the Assam police will pick them up. Right? The nature of digital speech is also such that there are no geographical boundaries for online speech. So, but at the same time, if there was inflammatory speech of a different kind, which doesn't sit well or which sits well with the government, in fact, that the government might not take action about. Right? You've had the Supreme Court in several instances try and nudge the government. In fact, the courts had said that all DGPs will be held in contempt if they don't register hate speech cases. You take the case of Yati Narasimhanand or any of these instances, right? It needed a judicial push for the police to even file FIRs. So it's really about how the state decides to implement these laws rather than there being a vacuum for, a better definition or a better law.
And the other issue with hate speech is that, when we talk about intention to cause injury, disharmony, feeling of enmity or ill will, all this can be subjective, right? Not everyone will see something as hateful.
No, absolutely. And that is why the judicial process is really important. There can be a case of 505 registered against you, that you outrage religious sentiments of somebody. Take, for example, the controversy in Uttar Pradesh recently on the I Love Muhammad posters, right? But eventually, do these stand the test of a trial in court? The state has to prove that this, in fact, incited religious feelings and caused communal disharmony. So many of these cases don't. So, which is why you look at their conviction rates. NCRB data tells you that the conviction is very low. On the other hand, it's also difficult to police hate speech in a way, right? Because like you said, it is so subjective because it also depends on who is making it, right? A college student in some part of the country putting up a WhatsApp status is not the same as a political leader dog whistling against the minorities from a political podium, right? In an election rally. The nature of this speech is innately different. The power dynamic is very different. So how do you go about policing both of them at the same level, right? And this also has to be coupled by some kind of an action. For instance, is there defilement? Is there an incitement to violence? Is there a call for violence, right? These things also determine whether they fall under the broader definition of hate speech. But having said that, like most criminal laws, the process is really the punishment, right? There is, say, a case of hate speech filed against you. You're already been booked and arrested by the police. As of now, our IPC provisions, most of these sections on hate speech carry a 3-year sentence, which, as per the Supreme Court's guidelines, if it's an offense that carries a sentence of less than 7 years, you can be granted bail automatically. So getting bail in these cases is relatively easy because of how the Supreme Court's liberally interpreted bail provisions. But which is also why Assam police arrests people under sedition, because, sedition is punishable with a jail term of 7 years. So it makes it that much more difficult for someone to get bail. Now, the Karnataka law goes one step further and says for so-called repeat offenders, the maximum sentence is actually 10 years, right? Which makes getting bail impossible. So in most of these laws, it's because the process is itself a punishment. It doesn't matter whether they actually stand the test of a trial. It matters what happens immediately.
Right. And even besides jail terms, this bill also allows the state government to remove content from online platforms if they think it falls under the broader definition of hate speech. So could you talk a bit about that?
Yeah, that is a more immediate and a more relevant or, relatable punishment in that sense. Because say my Twitter posts are taken down or my Twitter handle is taken down, right? Or even if I'm not arrested, that is a violation of my right to free speech. And the remedy for that is bureaucratic, often involves me going to court. So if you look at a classic citizen versus state issue, the citizen has a very, very difficult recourse against the might of the state in policing this speech.
Okay, so we've talked about repeat offenders and what this bill proposes to do to them. And we've talked about the powers it gives the government to take down online content. What other sort of punishments does this bill propose for those who violate this law?
So the other important thing that the Karnataka bill proposes is to look at punishing organizations and institutions collectively for the so-called hate crimes. And they define institutions very loosely to say association of persons, whether registered or not. So, which means if, say, an employee of an institution has made certain comments which are allegedly under the definition of hate speech, right? So the institution collectively might be responsible for it. Of course, it has a rider which says, but if it's done despite all the checks and balances or whatever, then the person will not be punished. But the problem is really whether you prima facie try to stop this or not is something that will be determined in trial. And before that, what the bill does is sort of bring in this guilt by association. Just because you spoke something that is allegedly hate speech and we work together, both of us can be booked under the law. That's how the section is framed as of now. And that's a really troubling part because in speech, you can't really bring in this guilt by association because I'm not responsible for what you spoke unless you prove that I colluded with you or I abetted you or I was part of it in some way or the other. So that's a big troubling part of what the Karnataka law does. And of course, they do talk about repeat offenders, which for the mandatory minimum sentence is 1 year, which may extend up to 7 years. But for subsequent or repeat offenders, the punishment will not be less than 2 years, which can extend up to 10 years. So the sentence here is not accidental. It's by design in a way to circumvent, like the Assam police is doing, the Supreme Court guidelines on bail, right?
And Apurva, does this also raise concerns about self-censorship? For instance, if I know that what I say could be construed as hateful under this law, then I'm less likely to say it, right? And when it comes to genuinely hateful content, that's, of course, a good thing. But if it also stops me from saying other things, then it essentially curbs my freedom of expression, right?
No, absolutely. That is essentially what the chilling effect is. Because something is defined so broadly, I don't know what is so-called criminal territory and what is not. So, I might as well stay clear of it. You speak to many people who were earlier very active on Twitter, for example, right? And now with all the, even say with all the trolling and the hate that you get on Twitter, there are many who have chosen just to not tweet, right? Just to not put your opinions out there. So that is essentially what chilling effect is. And when that policing happens, not just by some trollers on Twitter, but by the state itself, it has a bigger impact. But the other reason why this is also happening is, the larger context is that there are only very few opposition rule states. And like when, say, states like Assam decide to somehow take up the role of policing speech across the country on certain issues, right? And the opposition rule states are also coming from this place that we also have to respond to speech that kind of may contradict our politics or, that we have to deal with politically. In a sense, that's why this law is framed, which also reflects how terrible the climate of speech is in the country right now, right? It is to show that we are also doing something about it. So, but on an issue like free speech, an additional law will really not solve the problem. It'll only do more damage to the right to freedom of speech and expression.
So then I'm thinking, what is the right way to punish hate speech? Is it just getting people at the judicial level or at the police level to interpret these laws in the right way? Is that the only way?
Look, it is extremely difficult to police speech, especially when the boundaries are almost non-existent with online spaces, right? Someone sitting in the US can incite violence in India. That is a reality, and it also reflects how we kind of look at speech now, right? Earlier, if it was a stage in Karnataka, someone speaking in Karnataka, they would be arrested. But now, anywhere in the world, and we are very interconnected, and it's very difficult to police speech. Having said that, it also reflects the politics of our times, right? What is hate speech and what is not? In cases where there is a serious threat to public order, right? Where there is an actual incitement of violence, an FIR has to be filed and action has to be taken. And when that doesn't happen, citizens do have a right to knock on the doors of the court. And in these cases, the courts interfere and the courts do call for registering an FIR. But that is serious work. Ultimately, this cannot happen if the state doesn't cooperate. So these are not things that can just work in isolation, that, hate speech will be tackled if the citizen wants it, if the court wants it, but it all has to work together in that sense.
And next, we shift our focus to Odisha's Malkangiri district, where the murder of a 55-year-old tribal woman earlier this month has triggered a wave of violence that authorities say was fueled not just by the crime itself, but by decades-old tensions over land and resettlement. Now, to understand these tensions, it's important to know, under the Dandakaranya project, the central government had created the Malkangiri villages for the rehabilitation of Bengali refugees who fled what was then East Pakistan for India.
So initially they wanted to settle in West Bengal, Tripura and Assam, but when the capacity of these three states to rehabilitate these Bengalis reached at a certain level and they couldn't rehabilitate more, so Government of India started looking for some alternate areas.
This is the Indian Express's Sujit Bisoyi, who reports on the state for the paper.
So in that way, they identified this Dandakaranya region, which is a vast land comprising some parts of Odisha and Madhya Pradesh. Now these are under Chhattisgarh and some parts of Andhra Pradesh. So the proposal was moved, survey was done, and ultimately they identified around 30,000 square miles of land in Odisha and Chhattisgarh as an appropriate land to resettle and rehabilitate these Bengali migrants who came from East Pakistan and present-day Bangladesh.
And so the Malkangiri villages, known as MVs, were among the planned settlements created under the scheme.
Basically, two from Odisha and two present-day Chhattisgarh and erstwhile Madhya Pradesh, those were identified to settle these Bengali refugees. So, in that scenario, these Malkangiri villages were created basically.
And over time, the state-driven demographic transformation altered local land relations and economic hierarchies.
Well, as I said, the tension between these refugee Bengali settlers and the tribals, that was always there because there are several reasons, but the prime reason is basically the dispute over the land. And Malkangiri is a tribal dominated area. Tribals were living there, full of forests and all that. But after the government launched this Dandakaranya project and resettled the Bengalis there is a kind of insecurity among the tribals that started as soon as the project was launched. And the tension was always there because the Bengali people alleged that the settlers, they encroach upon their land, they illegally took over the land, taking benefit of their lack of resources and education. So in larger case, that was the trigger why this violence escalated in Malkangiri recently.
And so to understand how this recent murder case has refueled these tensions, we speak to Sujit in this segment, who starts by telling us how it all began.
In the first week of December, maybe on 4th December to be very precise, the police, a day after a missing complaint was lodged about missing of a 55-year Koya tribal woman. So a day later, on 4th December to be precise, the police recovered the body from a river bank, but the body was headless. So from the clothes and other ornaments, the family members identified that this was the same woman whose missing complaint was lodged by their family members. And this was happened on 4th December, on Thursday. But on 7th, Sunday evening, the anger among the tribals came out after police detained one person from the nearby Malkangiri village, that is MB26. They detained a 44-year-old person from that village. After that, on Sunday, around 1,000 tribals, they armed with their traditional weapons, they entered into this MB26 village and they started vandalizing the shops, setting houses on fire and vandalizing other structures. That continued even on Monday in presence of police, in fact.
And Sujit, what's interesting is that the administration ordered internet suspension for a week. So why was that?
The administration, because of the violence that continued even on Monday as a precautionary measure and to avoid further escalation of the issue, the administration at the first place, they imposed prohibitory order on Sunday evening only. And a day later, the internet ban was also imposed. That was enforced around for a week, just to ensure that no false information was circulated that would further escalate this violence.
Right, and as you mentioned earlier, that land ownership disputes are often contentious here. And this is also being seen as the motive behind the murder. So why is it that land ownership is such a flashpoint in this region, even decades after formal settlement and citizenship of Bengali refugees.
As I said, Ichha, this land dispute was always there because this after the Dandakaranya project was launched, the tribals were very insecure, and even today they realize that these Bengali settlers taking benefit because the tribals are not very educated and they lack resources and they remained poor. But many of these Bengali settlers, they earned a good wealth in that region and settled there with their family members. So that is a point, and the tribals people always allege that the refugee settlers, they took over their land by fraudulent means and they encroach upon the government land, and later they took it to their possession. So this land dispute and lack of access to resource and economic marginalization, basically these are the issues that was the flashpoint between the tensions between the tribals and the Bengali settlers in Malkangiri. And previously also there were deadly violences occurred in that region. So before Dandakaranya project was launched in 1958, there was no such land structure, but the Malkangiri region was always resided by the tribals. So they thought the land was there.
Right, and you also highlight that similar tensions have erupted earlier as well, like in 2001. So talk a bit about that.
In 2001, October and November, there were deadly violences occurred between these Bengali settlers and the tribals when over 8,000 Bengali settlers, they gathered and they protested outside the Raighar block headquarters in Navrangpur district. That was also part of this Dandakaranya region. And then it was under the undivided Koraput district when the Bengalis were settled. They protested outside Raighar block headquarters office demanding that their land should be returned to them, which were allegedly taken over by the Bengali settlers. And the protests become violent after the Bengali settlers, they set on fire the block office and they indulged in vandalism. So police resorted to firing and 2 tribals were killed in that incident. And this protest continued for around a month, and in November, again because of violence, police had to resort to firing. In that incident, 3 more tribals were killed.
And Sujit, how has the Odisha government responded to these tensions?
Well, after the incident, this incident didn't blow up out of proportion because of the timely intervention, we have to say, because the police, the administration imposed prohibitory orders and they imposed the internet shutdown immediately. Then Central Armed Police personnel were deployed who continue to guard the area till today because people started returning to their home in MB26 and as tension still continues to prevail. So internet ban has been revoked, but deployment is still there. And administration held peace meetings with heads of communities from both the side, tribals and Bengalis, who the administration claimed that they agreed for peace to restore peace in that region. And as the land dispute is the reason, the administration said that they will also try to resolve this issue. In the meantime, 2 ministers from the state government, Deputy Chief Minister K.V. Singhdev and 1 more minister, they visited that region and they submitted a report to the Chief Minister. And what we learned that they've also mentioned in the report that the land dispute was the reason and government need to take some concrete steps to resolve this land dispute issue between the tribals and Bengali settlers.
And so what would these concrete steps look like? Do we know?
Well, we would not be able to say what concrete steps, but what the experts say that there need to be a fresh survey, land survey, so that the areas can be demarcated properly. Land belong to the tribal, they need to be told these are the land and land owned by the Bengali settlers. That the land survey basically, because land dispute is the core issue. So the suggestion from the expert and senior officials, even we spoke out of curiosity, they said that a fresh survey need to be done to demarcate the land, and that could be the way forward actually.
And in the end, we take a look at how an Indian individual has been linked to one of Australia's worst mass shootings in recent history. The attack in question took place at Bondi Beach in Sydney during Chanukka by the Sea, a Hanukkah celebration organized by the Jewish community. During the roughly 10-minute assault, 2 gunmen opened fire on people attending the event, killing 15 people, including a rabbi, a Holocaust survivor, and a 10-year-old girl. These 2 shooters were identified as 50-year-old Sajid Akram and his son, 24-year-old Naveed Akram. Now, 2 days after the mass shooting, Australian authorities confirmed that Sajid actually had links to Hyderabad. Telangana police said that he was originally from Hyderabad and migrated to Australia in November 1998 after completing a Bachelor of Commerce degree. He had limited contact with his family in India over the past 27 years and visited the country 6 times after migrating. As reported by the Indian Express's Nikhila Henry, Telangana Director General of Police, B. Shivdhar Reddy, said the factors that led to Sajid Akram's radicalization had no connection with India. He said the individual had lived in Australia for over 2 decades and that there was no evidence of links to extremist activity in India. Investigations have revealed that the father and son traveled to the Philippines for most of November before the attack. Philippine immigration officials said Sajid Akram entered the country on 1st of November on an Indian passport, while Naveed Akram traveled on an Australian passport and the two returned to Sydney on the 28th of November. Henry highlights that Philippine authorities said the pair declared the city of Davao as their destination, though the military said it could not confirm whether they received any form of training during their stay. Officials noted that extremist networks have operated in parts of southern Philippines in the past, though their influence has reduced significantly in recent years. Australian Federal Police said early indications pointed to a terrorist attack inspired by the Islamic State. Police said a vehicle linked to the younger shooter contained improvised explosive devices and homemade flags associated with the organization. Videos circulating online showed Naveed Akram preaching in suburban Sydney prior to the attack. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank, Bhargava and me, Ichha Sharma. If you like the show, do subscribe to us wherever you get your podcast. You can also recommend it to someone you think may like it, with a friend or in your family. This is the best way for people to get to know about us. You can also tweet us at Express Podcast or write to us at podcast@indianexpress.com.